Hello, good evening everyone. Uh, Thank you Dr. Viral Cha for accommodating me in your instruction course of medical legal aspects. The topic allotted to me is Consumer Protection Act 2019. Myths and facts explained for the ophthalmologist. Basically, Consumer Protection Act was there since 1986. But then new provisions were added around 2020, but the name of the act is 2019. And it is quite problematic act, and those revisions which government tried to make were troublesome for medical profession. What new things were added in this particular act apart from previous act? So this particular slide explains what were the additions and what were the changes. First thing is, there was a rumor that this particular CPA 2019 is not applicable to medical profession. And so there was confusion amongst the minds of people of medical profession whether it is applicable to them or not. So they were very happy. So there were messages moving everywhere that it is not applicable. But unless and until medical profession is excluded from the list of the government, that it is not applicable for that particular profession, it is applicable to all other professions. So it is applicable to medical profession also. So just take it from me. Another thing is compensation amount was increased, and that was the worst thing. From lakhs of rupees it went to crores of rupees. But only thing is, there is one provision in that act, that is that particular compensation amount is linked with some in some way that what are the bills produced. Then one important thing is that in the past that particular CPA complaint was lodged in the area where the doctor was practicing, because that was the jurisdiction. And now according to this one, the jurisdiction can be anywhere in India. Suppose the doctor is in Kochi and patient is from Chandigarh, he can lodge the complaint in Chandigarh also. And that is quite troublesome for that medical practitioner. And then one important addition is that provision of consumer mediation cells. So this is that way good or good way, good and bad. Good in the sense that the case can be settled, but there are certain agencies, they are taking advantage of this and they are trying to become mediators and they are trying to take out the money from the medical professionals just for settlement purpose. So this Consumer Protection Act basically is related to doctor-patient relationship. In the past, doctor-patient relationship was very good, not that hampered. And according to this particular law, doctor was the profession, but now they are treating it as business. Doctor is a seller. And the same way patient was client in the past, but now he is a buyer, he is the consumer. So this way the definition has been changed. So they are linking it is pro-patient. What government thought that it will be beneficial for the patient. But then in the end, it is becoming anti-doctor. But patients are also receiving bad taste of it. Like defensive practice, so many investigations are needed just to safeguard the medical profession. For medical legal protection, what has been done for that? Few of the investigations are needed. CT, MRI, CAT scan is also advised. And patients and relatives, they may feel that it is not that important why it is done. But then to protect doctor himself, he tells that some diagnosis should not be missed. And most of the times even second opinion is asked for. So defensive practice is the trend. There is faith. There was faith. Still there is faith. But then element of suspicion has been increasing in the patients and relatives' minds. So that is the worst part of it. And that way, society, doctors, patients, everyone is getting affected. So both are affected. So the goal which was set in front of the government is not achieved. So doctor is answerable surely to medical council, civil courts, criminal courts, consumer redressal, Janta Darbar, all simultaneously or sequentially. So this is the worst part. Then CPA is a special law of civil nature with the aim of a social welfare to protect consumers with following features. No court fee. Now it is up to 5,000. Again, this is a very small amount. Simple procedure of filing, hearing and deciding, etc. Summary trial is also there, and speedy redressal, that is the aim, which is still not achieved. So non-judicial members of forum, one has to be female. So that's what their description is. Not a court, but has a full force of it, that is quasi-judicial. Majority opinion is the order of the forum. Act is compensatory and not preventive or punitive. That is very important. Applies to all paid goods and services, but only free services covered are medical. That is quite unfortunate. So jurisdiction, district forum, it was less than 20 lakhs in the past. They have proposed up to rupees 1 crore. State commission in the past, it was 20 to 100 lakhs. That was up to 1 crore. Now it has been raised to 10 crores. So appeals plus administrative powers. In national, it was more than 100 lakhs. That was up to 1 crore. Now it has increased to more than 10 crores. So revision appeals, administrative, and no power of reviewing own orders. So these are the worst things. The amount has gone in crores and crores of rupees. So period of limitation, 2 years. For appeals, 30 days. So condonation possible. So what is the procedure? Summary procedure: complaint in 4 or 6 copies with affidavit referred to opposite parties. Reply in 30 days. Can be extended more 15 days. Then hearing by president, one president, at least one member. Lawyer is not mandatory, so anybody can go there. Evidence of affidavit, expert, book references, if elaborate, may be asked to go to civil court. Order to be signed by president and only minimum one member. So ex parte decision is possible. Suppose the complaint is against the medical professional and he is not going there, the ex parte decision also can be taken. Then appeal system. So district forum, if not resolved, state commission, if not resolved, it goes to national commission, and at the end, Supreme Court can be attended. So proposed changes: power up interim orders, power up injunctions, increasing pecuniary jurisdictions, national commission, only appellate jurisdiction, and more benches of state and national commissions. So I am thankful for giving me the opportunity, and I pray Almighty all of you remain out of all this. Thank you. Thank you so much.